Good morning, good afternoon, and good evening, wherever you are in the world. Thank you for attending. My name is Mildred. And today, I hope you're ready to know more about data privacy. And if you have any questions, kindly send it to our comment section, and I will get back to you. There are many data privacy laws around the world. The most common are Data Privacy Act of 2012, Republic Act 10173 that we have here in the Philippines. We have General Data Protection Regulation, which is GDPR 2018, which is applied to European countries. And we have California Consumer Privacy Act of 2018, which is in California, and the Personal Data Protection Act in 2010, which is in Singapore and Malaysia. And it is interconnected. Like example, if you are dealing with clients from Europe, and then you have to comply with GDPR. Same goes with the Data Privacy Act, CCPA, and PDPA. But today I will discuss the basic contents of data privacy laws. I have a small disclaimer. I'm not a lawyer, so I don't do legal advices. I am a certified data protection officer, and we are here to help you and assist you to comply with the data privacy laws. In this digital world, accessing personal data is very easy. With one click of your finger, all your data will be transferred from one computer to another. And once your data or information entered into the internet, it will stay forever there. So we should always be careful or be cautious of what we are sending or what we say. Even though we have a lot of advantages with the new technologies that we have today, like paying your bills online, have an online market where you can shop while staying at home. But are we aware that we need to protect our data or information that we are putting in the website or in the system? So the question is, are we protected, or are we even aware that we should protect our information from being misused or theft? And the main question is, how can we comply with the Data Privacy Acts? This is one of the articles that recently it is the reality that we have today. Machines or internet have lots of information about us, and if we are not careful enough, like posting in social media, there is a possibility that we can experience identity theft and misuse of our data. When we hear AI, we only think about artificial intelligence, but usually we don't care or don't pay much attention to what it can really do. We became dependent with artificial intelligence in our daily routine. Well, who will not love that? Um, as it makes our life easier and that we can catch up with the evolving digital world. But for those who are vigilant about privacy concerns, there are so many things that we need to pay attention. And if we are talking about artificial intelligence, who knows what can AI do in the next future? And we are all excited for the next evolution. But don't get too excited. As the technology develops, we also need to adapt in these changes and learn more how to protect our data. And these technologies are also used to track us and know everything about us. Security cameras are seen everywhere, and all the technologies that we have in our house right now, is it either listening or recording to whatever we are saying or even watching us. And sometimes immediately you will receive adverts about a certain product that you are just talking about. How crazy and convenience, right? But don't be so relaxed about it, because in these cases, we became the product or easy target of hackers and different kinds of breaches. This is why we should know how important the data privacy law for our security. We should also be cautious on what we download. Sometimes a simple or cute game or an app will cause us a huge deal in terms of data privacy, as it collects our IP location, uh, our IP addresses, and what sites we visited, what site we visited. There are some few definition of terms that we will tackle for today. First is processing. Processing refers to any information or a set of operation performed about upon personal data, including but not limited to the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure, and or destruction of data. Let's start by saying that personal data must be processed lawfully, fairly, and in a transparent manner in relation to the data subject. So lawfulness, fairness, and transparency, which make the processing legitimate. Processing can may be performed through automated means or manual processing. So if the personal data are contained or are intended to be contained in filing system. Next, we have consent. It refers to any freely given specific information indication of will, where the data subject agrees to the collection and processing of his or her personal, sensitive information or privileged information. There are kinds of consent I will discuss today. First is implied consent. It is the assumption that a person have given permission for an action which is inferred from his or her action rather than expressly or implicitly provided. For example is, for instance, an individual must give consent to be treated by his doctor, consent to allow a mechanic to work in his car, and consent to allow his attorney to present him in a legal manner. And we have the next type of consent, which is explicit consent. Explicit consent means that an individual must provide a positive indication that they agree to their personal data being shared. This could take a form of taking of an opt-in box or another action that signifies agreement, such as oral confirmation or the provision of the contact details where the individual has been clearly informed that by giving these details, to they agree to share their data. Next is we have personal information. So personal information refers to any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be responsibly and directly asserted by the entity holding the information, or when put together with other information, would directly and certainly identify an individual. So personal information is any factual or subjective information, whether recorded or not, about an identifiable individual. In today's digital economy, your personal information is the new currency. Your preferences, your likes and dislikes, and facts about you are bundled up with thousands of other people's. All help makes marketers and businesses refine their products and services. Often, this information is helpful as it ultimately helps you, the consumer, to acknowledge unknowingly shape a product, service, or website experience, but sometimes it can be used illegitimately or in a harmful way. Next, we have data subject. This refers to an individual whose personal, sensitive, personal, or privileged information is processed. Data subject refers to any individual or person who can be identified directly or indirectly via an identifier such as name, ID number, location data, or factors specific to a person's physical, psychological, genetic, mental, economic, cultural, or social identity. In other words, a data subject is an end user whose personal data can be collected. So there are different types of information. First, there is a sensitive information. It refers to a privilege or it refers to privileged information that only certain people are allowed to see. That is therefore not accessible to anyone. If sensitive information is lost or used in any way other than intended, the result can be severe damage to the people or organization to which that information belongs to. It also it also have the it can also have your race, health, education, government licenses, etc. So what is personal information? Personal information is also called PII, that is personally identifiable information. It is a data that can be linked to a specific individual and used to facilitate identity theft. For example, knowing a person's social security number and mother's maiden name make it easier to apply for a credit card in their name, and knowing the person's passport and visa number make it easier to create a false document. Most people have personal information distributed across a variety of organizations and industries, such as protected health information, such as your medical records, laboratory tests, and insurance information. We have educational information, such as your enrollment records and transcripts, financial information, such as credit cards, banking information, tax forms, and credit reports. Next, we have privileged information. Means any information in written or oral, electronic, or other tangible or intangible forms, including any communication by or to attorneys' memoranda and other materials prepared by attorneys or under their direction. And another example is when you confess to a priest, they are practicing the seal of confession. And if you have some medical records that only you and your doctor should know. Next, we have personal information controller. It refers to a natural or juridical person or any other body who controls the processing of personal data or instruct another to process personal data on its behalf. So controllers are the main decision makers. They exercise overall control over the purpose and the means of the processing of personal data. Personal PIC refers to a person or organization who controls the collection, holding, processing, or use of personal information, including a person or organization who instruct another person or another organization to collect, hold, process, use, transfer, or disclose personal information on his or her behalf. Next, we have PIP or Personal Information Processor. It refers to any natural or juridical person or any other body to whom a personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. Personal information processor refers to uh, any person that keeps our file. Example in the field is mostly are the secretaries, technicians, or deans. Next is data protection officer. Data protection officer is the one who is responsible for the overall compliance of the company in data privacy law. And if a certain company has branches in different places, you can assign compliance officer of privacy, which is called COP, which will act as a BPO in a certain branch. But always remember that we have only one BPO, and we can assign the different PIC and PIPs. Data subject, this is me and you, regarding our information such as age, name, gender, email addresses, and any information that points back to us. Next is data sharing. It is a disclosure or transfer to a third party of personal data under control or custody of personal information controller. We should always be careful in disclosing information. We cannot just share information without the consent of the data subjects. And if we have a consent, we should always prepare a non-disclosure agreement to make sure that parties will protect the privacy of the data subjects. So what is Data Privacy Act? But before we go that, what does privacy means? It is the state of or condition of being free from being observed or disturbed by another person, or the state of being left alone. The right to privacy often means that right to personal autonomy, or the right to choose whether or not to engage in certain acts or have certain experiences. Privacy Act is implemented mostly across from all over the world. It is a law of protecting individuals' personal information in information and communication systems, both in the government and private sectors. It is implemented to protect the collection, usage, storage, retention, and destruction of information. So why do we need to comply? Why Data Privacy Act is very important if we are dealing with information, and why there is a need for you to comply and know about data privacy laws. Of course, we don't want our data will be breached. We don't like to pay fines and especially go to jail because you don't know how to deal with how to comply in Data Privacy Act. And it is not a small amount of money that we are talking about if ever there is a breach, that it can cause a huge loss and disruptions in operation in one company. So penalties will differ as per country where the data privacy breach happens. Next, we'll discuss about the personal data processing flow, or we call it audit trail flow. We will discuss why we need to collect the data, how are we going to use the data, where are we going to store it, till when are we going to store the data, and how are we going to dispose the data. First is collect. Data collection enables a person or organization to answer relevant questions, evaluate outcomes, and make predictions about future probabilities and trends. So there are different ways to collect a PII, or personal identifiable information. These are surveys, online trackings, transactional data tracking. We have online marketing analytics. We have social media monitorings, collecting subscription and registration data, and in-store traffic monitoring. So personal data must be collected in a declared, specific, and legitimate purpose, and the data subject must be informed about the scope and purpose of processing. Consent is further required if sharing information with affiliates or even mother companies. There are few things that we need to consider also. First is determine what information you want to collect. You should have a time frame for data collection, and determine your data collection methods, and determine what are the data that you need to collect, analyze the data, and implement your findings. So we usually collect for some few reasons. First is we collect data for improving your understanding about your audiences, identifying areas for improvement or expansion, and predicting future patterns. And we have better personalizing your content and messaging. Next is we have use. In marketing, without big data analytics, companies are blind and deaf, wandering out into the web like a deer on a freeway. Whether you are trying to improve customer loyalty and engagement, optimize your performance, or make pricing decisions, big data in marketing has proven to be an indispensable tool. Whether in whichever industry you work in or whatever your interest, you will almost certainly have come across a story about how data is changing the face of our world. It might be a part of study helping to cure a disease, boost company revenue, make a building more efficient, or be responsible for those targeted ads you keep seeing. After data collections, all the data needs to be processed, researched, and interpreted by some someone before it can be used for insight. Next is we have storage. So what are the tools that we need to use to store our data? One tools is the cloud provider, but we have some few tips on how to select a cloud provider. First is security capabilities. One of the major factors holding businesses owners back from embracing the cloud is the concern over security. So whenever you use a cloud storage provider, you're essentially giving your valuable data to a third party with the expectation they'll keep it safe. So when you pick a cloud storage provider, make sure they provide sufficient security measures such as this includes antivirus software, data encryptions, firewalls, and routine safety audits. Next consideration is the price. While it may not be a surprise, bringing down operating cost is a major reason for many companies to have those who have started using the clouds. And with so many cloud vendors striving for your business, prices have become very competitive. So you should figure out what pricing plan works best for your company. Next is the storage location or the data storage location. So storing data in a cloud isn't some nebulous abstract concept. That data is stored in an actual physical location. So if a vendor stores your data in a different country, that country law may affect who has access to it and how it can be controlled. And another factor to be considered if the data storage location is at risk for natural disasters like tornadoes, earthquakes, or hurricanes. Knowing your cloud vendor has a plan for how to protect and save your data in case of emergency strike can play a big role in decision making. So next is we have service level agreement. This may include such as what kind of data will be restored, how it will be restored, or how it will be protected, how problems are solved, and a variety of other important items critical to understanding how the cloud vendors operates. Make sure you know what's a prospective cloud vendors SLA entails to get a good idea what you can expect from them. Next is techno support or tech support. No technology is perfect and the problem will arise from time to time. So we need to find out in choosing a cloud server. We need to find out how they handle tech support. We can ask them how if they're available for 24/7 or in holiday, or how quick they respond to your concern or problem. So a vendor does not, in this tips, if a vendor doesn't meet one of the requirements, then you should find a better one, or it is the best tips that you can. Next is transfer or retention. Data retention or record retention is exactly what it sounds like. The practice of storing and managing data and records for a designated period of time. There are many numbers of reasons why a business might need to certain data. It is to maintain accurate financial records, to abide by local, state, and federal laws, to comply with industry regulations, to ensure what information is easily accessible for e-discovery and education purposes, and so on. To fulfill this and other business requirements, it's imperative that every organization develop and implement data retention policies. So what are the best practices for a data retention? First is we need to identify and classify the data your organization holds. So classifying data is the best practice for data retention because not all data requires the same retention. Recognizing this, many frameworks and legal regulations have specific requirements that encourage organizations to classify data. Next is know which legal requirements apply to you. This is why when following best practices for data retentions, organizations should consult either internal or external regulatory compliance specialists to determine which legal requirements for data retention apply to their organization. Next is to delete data set once it is no longer required or after the data retention period has been met. Holding into data longer than the required by law or longer than needed for use can have various ramifications, including but not limited to it increases chances of experiencing a data breach or security breach, placing client data or at greater risk for being breached. It's contributing or cluttered hardware or softwares, making it difficult to find data that's actually needed, expanding the regulatory compliance burden related to data access. So a company should have a data retention policy. So a data retention policy or a record retention policy is a business established protocol for maintaining information. So the policy will define the data needs to be retained, the format in which it should be kept, how long it should be stored for, whether it should be eventually or be achieved or deleted, who has the authority to dispose of it, and what procedure to follow in the event of policy violations. We have next we have delete or destruction. Data destruction or sanitation is an important step in the data lifecycle. Once data has reached the end of its life or is deemed tribal, obsolete, or redundant, it's important to dispose of that data securely. As such, simply snapping a hard drive in half isn't a suitable technique for permanently erasing end-of-life data. If a company goes down the physical destruction route, it should ensure that the media is shattered into many pieces as possible. Most professionals would recommend using a specialized hard drive shredders. For devices that use flash memory, the process is a little different. If the memory chip itself is destroyed, the data can't be recovered. But if it survived, it can be transplanted into another circuit board with a fresh controller chip, and the information can be traveled without much trouble. And the information can be accessed without much trouble. It's easy to assume that physical destroying media is guaranteed way of securely erasing the data, but that's not the case. Doing the job properly is often a time-consuming and any other method and requires no less rigor. You can use a crusher or shredder for this particular method of data destruction. These are the common rights that an individual or data subject should know. Sometimes we are doing it already, but we are not aware that it is as per the law. So here we are. First is right to be informed. As a data subject, you have the right to be informed that your personal data is being or was collected and processed. In informing, it should be transparent, simple, and easy to understand. Individuals have the right to be informed about the collection and use of their personal data. You must provide individuals with proper information, including your purpose for processing their personal data, your retention periods for that personal data, and who it will be shared with. One of the example of this is when you see a cookie that pops up when you go to a certain website. Once we click it, means we give our consent, and we are aware that they will use our data. So being open and upfront about what you do with their personal data helps you to deal with people in a clear and transparent way and empowers them. This makes good sense for any organization and is key to developing trust with individuals. Next, we have right to access. This is your right to find whether an organization holds any personal data about you, and if so, gain reasonable access to them. You may ask them to provide you with a written description of the kind of information they have about you, as well as their purpose for holding them. The right of access, commonly referred to as subject access, gives individuals the right to obtain a copy of their personal data as well as other supplementary informations. It helps individuals to understand how and why you are using their data and check if you are doing it lawfully. For example, once a company or organization get your PII or personally identifiable information, you have the right to access of whatever details they have on you. Sometimes you need to check if the data collected is accurate or need revisions, which is our next data subject rights. That is a right to correct or right to file. You have the right to dispute and have corrected any inaccuracy or error in the data or personal information controller holds about you. Once your data have some revisions, you should submit a request to change the necessary details, and the PIC or the Personal Information Officer, the Personal Information Collector, should act on it immediately and accordingly, unless the request is unreasonable. Once collected, the PIC should also furnish third parties with said information and ensure your continuous access to your updated information. Next, we have right to erasure or blocking. You have the right to suspend, withdraw, or order the blocking, removal, or destruction of your personal data. When can you practice your right to erasure or blocking? First, if your data is incomplete, outdated, false, or lawfully obtained. If your personal data is being used for the purposes you did not authorize. If your personal data is no longer necessary for the purpose of which they are collected. So you can decide to withdraw consent or you object to its processing, and there is no overriding legal ground for its processing. If the data concerned information prejudicial to the data subject, unless justified by freedom of speech or of expression, or at the press or otherwise authorized by the law, the processing is if the processing is unlawful, the personal information controller or the personal information processor violated your rights as a data subject. So you have the right to remove the data in certain project if you doesn't want to be a part of it anymore, and you can always withdraw your consent. Next, we have right to object. If the personal data processing involves is based on consent or in legitimate interest. Right to object can be exercised if the personal data processing involves is based on consent or on legitimate interest. The right to object is most specifically applicable when organization or personal information controllers are processing your data without your consent for the following purpose. If they will use your data in health research, you have the right to say no, or to whatever purpose they want to use it. So once the data collector is taking your data and you do not like to be involved anymore in direct marketing, profiling, automated processing purposes, then you always have the right to decline or object. So whenever you have a chance, you may assert it. You may assert your right to object verbally, be in a person or via a phone call, to have it formally documented. However, you must execute also a written request to the organization addressed to its data protection officer and have it received. Next is right to data portability. It allows you to obtain and electronically move, copy, or transfer your data in a secure manner or further use. Data portability allows you to manage your personal data in your private device and to transmit your data from one personal information controller to another. As such, it's promote competition that fosters better services for the public. If you consult or ask opinion about your health, you can ask your current doctor for a hard copy of your record to give to another doctor. It enables a free flow of your personal information across the internet and organizations, according to your preference. This is important, especially now that several organizations and services can reuse the same data. So in banking, the right to data portability may be used to reduce the risk of being locked in with one single service provider, thereby expanding customers' options and providing customer experience. Next is we have the right to complain. If you feel that your personal information has been misused, maliciously disclosed, or improperly disposed, or that any of your data privacy rights have been violated, you have the right to file a complaint with the commissioner. So once you have a complaint about your rights, you can always have a written letter submitted to the DPO of the company. Once received, they will reply within the allowed approximate days approved by the commissioner. And if you are not satisfied with the answer that you receive, you can always go to the higher ups, which is the commissioners, and file another complaint. Next, we have right to damages. You may claim compensation if you suffer damages due to inaccurate, incomplete, outdated, false, unlawfully obtained, or unauthorized use of personal data, considering any violations of your rights and freedom as data subject. And of course, once your data is misused or because of the inaccurate data, your reputation is damaged. Once you file a complaint and they agreed with your claim, then they can pay you with the compensation based on what data is breached. So there are consequences of non-observance of data privacy rights. These are loss of trust, harassments, damaged reputations, discriminations, loss of self-determination, loss of autonomy, loss of money, and stigmatization. So this is our subject rights, and now we will discuss the 5 pillars of compliance of data privacy law. First is appointing a DPO or a data protection officer. Ever wonder who will be responsible if there is a breach in one organization? There is a possibility that the DPO and the owner of the company can be jailed or be punished if the data of the company had breached. So that is why it is important that we have a data protection officer who will be responsible for the overall management compliance of the data privacy laws, because he or she will be a focal person who will make sure that the company is complying properly with the law. A data protection officer should be knowledgeable on how to comply with data privacy laws, flexible and ready to adapt to different circumstances, and a person who has trustworthy qualities, who is reliable and expert in the field of data privacy laws. You can employ or subcontract DPO, whichever is convenient to you. A breach may happen anytime, and having a DPO or a data protection officer and having the right policies can lessen the impacts of data breaches. Next is privacy impact assessment. So privacy impact assessment or PIA is an instrument for assessing the potential impacts on privacy of a process, information system, program, software, module, or other initiative which processes personal information and in consultation with stakeholders for taking action as necessary to treat privacy risk. So when is PIA recommended? First is when it has never been conducted by an organization for any of its data privacy system. When there is a new data processing system. When substantial changes are introduced to an existing data processing system. When there is a significant external developments that could impact on existing data processing. When an existing data processing system is involved in a major data breach or recurring security incidents, and when it is according to a predetermined schedule. So every company should conduct a privacy impact assessment, where company will acknowledge the weakest part of the organization that need much attention in terms of data privacy, which sections needs a lot tougher security. In conducting a privacy impact assessment, the process involves also all the stakeholders or those who are involved in keeping the data safe. They should be aware of all the rules and regulations in keeping the data secure. Next is we have privacy manual. Every company should have a privacy manual. All the employees should be aware of how to handle a PII or personally identifiable information. Most of the time, data controllers and processors are the one who are in charge in making the manual, where it should discuss how the organization complies with the data privacy principles and upholds the rights of the data subjects, both of which are laid out in the Data Privacy Act. In privacy manual, indicated the process or the step-by-step procedures that everyone should know. And once the data subject has a complaint or inquiry, where should he or she go? So the forms are also included in the privacy manual. Next is we have implementing privacy pillar. Next is we have implementing privacy and data security measures. In most cases, human factors are one of reasons for being breached when employees are not implementing the procedures or not paying much attention about the privacy manual that the PIC or PIP prepared in protecting the personal data. In implementing privacy and data security measures, organizations should conduct employee trainings to help maintain the privacy policies. In every project, you as a company should conduct a privacy impact assessment to lessen the trend of being breached and conduct penetration testings, especially if there are new products for security, if it's really useful or not. So we have data breaches. So what are the causes of breach? Here are the some examples of the breach that may happen to us. First is theft, loss, fire, flood, software malfunction. We have earthquake. We have phishing, ransomwares, DDoS, hardware malfunction, human error, forgery, and so on. So breach usually believed to have occurred if the data involves information that would likely affect national security, public safety, public order, or public health, or at least if it's contain 100 individuals, or information required by all applicable laws or rules to be confidential. So there are also personal data of vulnerable groups. Once there is a breach, a special incident response team will conduct the assessment. They should write the report, what are the data breached, and what are the steps that they need to do, and prepare the safety measures to recover from the breach. And the reporting of the breach should be done immediately to the data subject and the commissioner. And concealing a breach is a huge crime that can result to more fines and penalties. So monitoring the daily activities can help minimize breaches. We have to educate employees about importance of Data Privacy Act and have a regular backup. So if ever there is a breach or loss of data, you will always have a tool to keep the business running. It is better prepared than sorry. And remember, the more data you have, the higher risk of breach may occur or higher penalties. So if a certain data is not needed anymore, you should learn how to dispose or delete it and remove our mentality of what ifs, like what if we need it in the future. It is not a good practice anymore in this digital world that we live in. So here are one of the examples of the breaches that may happen to anyone once we are handling personal data or the handling is not properly addressed or implemented. It says why we need to comply in Data Privacy Act, especially if you are handling this sensitive data. So in this article, it is a case of ransomware where hackers collects the data subjects information of files, sometimes videos, and if you do not want to be public, you are forced to pay a certain amount of money. That's why it says here that they are like terrorists who collects money in exchange of your freedom or stress-free. Sometimes files are returned to the person after paying, but most of the time you will never hear about them. And sometimes we fear that once we paid a certain amount of money, are we sure that we will not be a victim anymore of ransomware? Next, this is one common scam also that we can hear everywhere, that they will call you and act as a certain agent, and if you are fooled, they will collect your information, and sometimes you fall for it because they offer free products and services that sounds promising. So be vigilant and don't get fooled. And this is the end result. Even big tech companies who are not careful enough with their clients' data, it will cause a huge breach and at the same time huge fines. And sometimes also it will may cause imprisonment. So always remember, you are your data. You should always protect it. Thank you for listening.